Malikhain, and for today, me and my groupmates will discuss to you about the RA 10175 or the Cybercrime Prevention Act of 2012. So, simulan natin itong reporting sa pagtatanong kung ano nga ba ang cybercrime. Ang cybercrime is a form of a crime where computer is the tool to make the offense. Ibig sabihin po, computer yung ginagamit para gumawa ng bagay na hindi maganda. For example, mag-access ng personal information ng ibang tao, mag-access ng business information na hindi naman sa'yo, mag-access ka ng government information which is totally wrong kasi wala talaga tayong rights na gawin yun at maling gawin ang bagay na yun. Tapos, isa din sa pinakatalamak na gawain under cyber crime is the child pornography, which is yung binebenta mo yung katawan ng bata para lang makakuha ka ng malaking pera, something like that. Pero hindi lang talaga bata yung madalas na nabibiktima ng ganito, kahit anong edad. So, pag-usapan naman natin ng batas paukol sa cybercrime, which is the RA 10175. So, this acts aims to penalize libel, cyberbullying, cybersex, child pornography, identity theft, or even unsolicited electronic communication. So, sa madaling salita, ito daw batas na ito ay pumapaukol o naglalayo na puksain ng mga krimen under cyber. Marami pang impormasyon ang nilalaman ng batas na ito, kaya naman sabay-sabay nating alamin ang lahat ng ito sa pamagitan ng pakikinig sa aking mga kagrupo.
Chapter 1 Preliminary Provision. In accordance to the Section 1, this Act shall be known as the Cybercrime Prevention Act of 2012. This Republic Act aims to penalize acts like libel, cybersex, child pornography, identity theft, and unsolicited electronic communication. Ang cybercrime law ay ginawa upang maparusahan ng mga nag-illegal access sa computer at illegal interception. Sa batas na ito ay hindi lamang tungkol ito sa cybersex o child pornography. Maaari ka ring makasuhan kahit sa simpleng pag-like o share ng mga impormasyon na makakapansala kanino man. Mahalaga na magkaroon tayo ng kaalaman sa batas na ito upang malaman natin ang ating mga karapatan kung ang ating pangalan o pribadong impormasyon ay kumalat man sa anumang website o sa mga social media accounts. Sa seksyong ito, dito kinikilala ng Estado ang mahahalagang papel ng industriya ng impormasyon at komunikasyon, tulad ng telecommunication, broadcasting, electronic commerce at pagpoproseso ng mga data para sa pag-unlad ng lipunan at ng ating ekonomiya. At nakapaloob din sa seksyong ito na dapat ang Estado ay magpatibay ng sapat na kapangyarihan upang mabisang maiwasan at labanan ang nasabing pagkakasala sa pamamagitan ng pagpapadali sa kanilang pagtuklas, pagsisiyasat at pag-uusig sa kapwa-antas, domestic man o international. At sa pagpapabilis nito, sa pamamagitan ng pagpapabilis ay magkakaroon tayo ng malinaw na komunikasyon sa international. In this section, mababanggit dito ang mga salita na makikita at nakapaloob sa batas na ito, tulad ng access, kung saan tumutukoy sa komunikasyon, pagtatago ng data, pagkuha ng data o paggamit ng anumang pagkukunan sa computer system o communication network. Isa pa, ang computer. Computer kung saan tumutukoy naman sa elektronikong kagamitan na maaaring gamitin sa pakikipagkomunikasyon. At ito din ang kalimitan na ginagamit upang ma-violate ang batas na ito. Sa batas na ito ay nabanggit din ang salitang cyber. Ito naman ay tumutukoy sa isang computer or computer network. Ito ay elektronikong daluyan kung saan nagaganap ang communication through online. Nabanggit rin dito ang cybersecurity. Ito naman ang kagamitan o tool na magtitiyak sa kaligtasan ng paggamit ng teknolohiya at upang maprotektahan ang ating cyber environment, kasama na ang mga pribadong impormasyon ng mga taong gumagamit ng teknolohiya. Isa sa mga nabanggit ni April kanina ang salitang illegal interception. At upang mas maunawaan natin mabuti ang ibig sabihin ng interception, ito ay ang pakikinig, pag-record, pagsusubaybay sa nilalaman ng usapan ng iba. Kabilang na rin dito ang pagkuha ng nilalaman ng data sa pamamagitan ng pag-access o paggamit ng isang computer system.
Chapter 2, Punishable Acts. Section 4, Cybercrime Offenses. The following acts constitute the offense of cybercrime punishable under this act. Offenses against the confidentiality, integrity, and availability of computer data and systems. 1. Illegal access, which means having an access to the full or any part of a computer system without right. Ito po yung pagkakaroon ng isang private site na walang legal approval ng kung sino man po. Number 2, illegal interception, which means having an interception made by technical means without right of any non-public transmission of computer data to or from or within a computer system, including electromagnetic emission from a computer system carrying such computer data. Ito po yung pagkakaroon ng information sa gitna ng dalawang taong pribadong nag-uusap sa kahit na anong site or social media. 3. Data interference. The intentional or reckless alteration, damaging, deletion, or deterioration of computer data, electronic document, or electronic data messages without right, including the introduction or transmission of viruses. Ito po yung pagsasabotahin ng files na di mo pagmamay-ari or intentional na pagsira or pag-delete nito. 4. System interference. The intentional alteration or reckless hindering or interference with the functioning of a computer or computer network by inputting, transmitting, damaging, deleting, deteriorating, altering or suppressing computer data or program, electronic without electronic data messages without right or authority, including the introduction or transmission of viruses. In some way, it is connected on data interference. But the difference is system interference means paninira o pagsabotahin ng kahit na anong system tulad ng PC or any device that carrying someone's file. Number 5. Misuse of devices. The use, production, sale, procurement, information distribution, or otherwise making available without right of like paggamit ng device sa paraang lumalabag sa cybercrime offenses po. Number 6, cyber squatting. The acquisition of domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same. In such a domain name is or paggamit sa pangalan ng malalaking brand or company para pakinabangan at magkaroon ng malaking tubo. Dito naman po tayo sa computer-related forgery. Ito po yung paggamit or pagpalit, pagdidelete intentionally ng isang computer data po. Number 2, computer-related fraud. The computer unauthorized input, alteration, or deletion of computer data or program or interference in the functioning of a computer system. Ito po yung paggamit ng computer upang makakuha ng data na di pang publiko o sa paraang lumalabag sa batas. Number 3, computer-related identity theft. The intentional acquisition, use, misuse, transfer, possession, alteration, or deletion of identifying information belonging to another, whether natural or juridical. Dito naman po tayo sa mga cybercrime content-related offenses po. Cybersex. The willful engagement, maintenance, control, or operation, directly or indirectly. Ito po yung paggamit ng computer system para sa mga sexual activity. Meron din po tayong child pornography. The unlawful or prohibited acts defined punishable by Republic Act number 9775 or the Anti-Child Pornography Act of 2009 committed through a computer Ito po yung pagkakaroon ng isang sexual activity or pagkakaroon ng interest na magkaroon ng any visual depiction involving any minor, mga kabataan po. Unsolicited commercial communications. Pag-receive ng any kinds of messages made by telecommunication services that don't have the purpose of information or any promotion. Meron din po tayong libel or the unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code as amended, committed through a computer system or other means may be devised in the future. Ito po yung pagpapublish sa public ng any information sa isang tao na walang katotohanan.
In Chapter 3, enumerate the penalties and corporate liability. So, base sa Section 8, pag ang isang tao na patunayan guilty sa kaso tulad ng illegal access, illegal interception, cyber squatting, cyber sex, at pag sila na patunayan guilty, pwede silang makulong at magbayad ng utang ng hanggang 200,000 piso. And for the penalty reclusion temporal or a fine at least 500,000 pesos if a person found guilty mentioned in Section 4. The Republic Act No. 9975 or the Anti-Child Pornography Act of 2009. If a person found guilty in this penalty, the penalty shall 1 degree higher imposed on Republic Act No. 9975. And for the Section 9, corporate liability. When a person found guilty in this act and the punishable act committed by a juridical person, the authority take decision on behalf of the juridical person. Juridical person shall be liable on time and equivalent fine or 10 million pesos. The liability of the juridical person shall be prejudiced by the criminal liability of the person who committed the offense.
Chapter 4, Enforcement and Implementation, Section 10, Law Enforcement Authorities. The National Bureau of Investigation and the Philippine National Police shall be responsible for the efficient and effective law enforcement of the prevention of this Act. Section 11, Duties of Law Enforcement Authorities. To ensure that the technical nature of cybercrime and its prevention is given focus in considering the procedures involved for international cooperation, cybercrimes are required to submit timely and regularly reports. Section 12. Real-time collection of traffic data. Law enforcement authorities with due cause shall be authorized to collect or record by technical or electronic means traffic data in real time associated with specified communication transmitted by means as a computer system. Section 13. Preservation of the computer data. The integrity of traffic data and subscriber information relating to communication service provided by a service provider shall be preserved for a minimum period of 6 months from date of the transaction. Section 14. Disclosure of computer data. Law enforcement authorities upon a security court warrant shall issue an order requiring any person or service provider to disclose or submit subscriber information. Section 15. Search, seizure, and examination of computer data. Where a search and seizure warrant is properly issued, the law enforcement authorities shall likewise have the following powers and duties.
Section 16, Custody of Computer Data, tells us that after the data was examined under a proper warrant, it should be deposited to the court. And of course, it should have a valid affidavit from law enforcement authority that's stating the dates and the time covered by the examination. Section 17, Destruction of Computer Data. This section tells us that upon the given expiration provided by the Section 13 and Section 15 The data gathered should be immediately and completely destroyed by the service providers and the law enforcement authorities. Section 18 Exclusionary Rule. In this section, it stated that all evidence without a proper warrant or taken beyond authority is considered invalid. Section 19 Restricting and blocking computer data. In this section, it stated that when the computer was found in violation, the DOJ shall issue an order to restrict and block to access that such data. Section 20 Non-Compliance. So this section tells us that when a person failed to comply the provisions of Chapter 4, specifically the orders from law enforcement authority, should be punished as a violation of Presidential Decree number 1829.
Under the Section 21 Jurisdiction, the Regional Trial Court shall have jurisdiction over any violence of the provision of this Act. Sinasabi rito na nakapaloob sa Section 21 na ang jurisdiction ng Regional Trial Court ay dapat magkaroon ng jurisdiction sa anumang paglabag sa probisyon ng batas na ito. Kabilang anumang paglabag na nagawa ng isang Pilipino saan man sa lugar ng komisyon. Ang jurisdiction ay magbabase sa alinmang elemento na nakapaloob sa bansang Pilipinas. Nakatuon ito sa paggamit ng anumang computer system na bahagi o nandito sa bansang Pilipinas. Sa oras na na-violate ng isang jurisdict na tao ang batas na ito habang siya ay namamalagi o naninirahan sa bansang Pilipinas, ay maaaring ipato sa kanya ang Cybercrime Law o ang Republic Act 10175 or also known as the Cybercrime Prevention Act of 2012.
International Cooperation. Section 22. General Principles Relating International Cooperations. All relevant international instruments on international cooperation in criminal matters. Arrangements agreed on the basis of uniform or reciprocal legislation and domestic laws to the widest extent possible for the purposes of investigations or proceeding concerning criminal offenses related to the computer system and data, or for the collection of evidences in electronic form of criminal offense shall be given full force and effect, supporting member state with ratification and implementation of international treaties, research and analytical work to increase knowledge and understanding of crime-related issues, promoting international cooperation, enhancing member states' capacities to counteract illicit drugs, crime, and terrorism.
In Chapter 7, competent authorities included in this law are the Department of Justice. According to Section 23, DOJ has created a Cybercrime Office designated at the central of this authority. Cybersecurity. Based on Section 24, the Cyber Investigation Coordinate Center or CICC, they created this within 30 days from effectivity of this act. And this is under of the Office of the President. This policy coordination is formulated that the National Cybersecurity Action. Section 25, the composition. The included agency are the Information and Communication Technology under the Science and Technology, and the Director of the CICC and the Chief of PNP and DOJ Office and one of the representative on the nation agencies. And for the Section 26, the CICC shall have the power and function to formulate the cybersecurity plan. And for the preparation of this appropriate measure to prevent this cybercrime, we should take some preparation to measure the prevention. to upon government agency to render assistance and to perform other matters related cybercrime prevention.
Chapter 13, Final Provisions. Section 27, Appropriation. The amount of 50 million pesos shall be appropriated annually for implementation of this Act. Section 28, Implementing Rules and Regulations. The ICT o DOST, the DOJ, and the Department of the Interior and Local Government shall jointly formulate the necessary rules and regulations within 90 days from approval of this Act. Section 29, Separability Cost. If any provision of this Act is held invalid, the other provisions not affected shall remain full force and effect. Section 30, Repealing Clause. All laws, decrees, or rules inconsistent with this Act are hereby repeated or modified accordingly. Section 33A of Republic Act No. 8792 or the Electronic Commerce Act is hereby modified accordingly. Section 31, Effectivity. This Act shall take effect 15 days after the operation of its publication in the Official Gazette or in at least 2 newspapers of general circulation.